Good evening, everyone, and welcome to the Pittsburgh Public Schools Policy Workshop. It's Wednesday, May 14th, 2025. I'm Sylvia Wilson, and I'm a co-chair of the Policy Committee. And tonight, we are going to review the Student Support and Positive School Culture Guide, the K-5 Student Code and Infraction Level Guide, and the 6 to 12 Student Code of Conduct and Infraction Level Guide. Ms. Elizabeth Sattler, an attorney with WPBK Legal, will lead tonight's policy workshop. Okay, so Ms. Sattler, I'm turning it over to you right now.
Thank you, Director Wilson. Good evening, everybody. I'm going to go ahead and share my screen. I have a PowerPoint to go through. Okay. I hope everybody is looking at a PowerPoint that says Board Policy Workshop, May 14th, 2025.
Yes.
Great. Okay. In this, we are going to this is the Code of Conduct policy. This policy is required to be reviewed annually and to be updated as necessary. A few years ago, this policy and the accompanying infractions were significantly updated. That has led to minimal revisions for this year. In order to properly take care of the Code of Conduct review process, the district meets with and takes feedback from stakeholders to discuss the Code of Conduct. The district met with the following groups prior to the proposed revisions: the ACLU, the ELC, the LTF, the PAC, and the PPS discipline. As I stated, significant revisions have been undertaken over the past couple of years, resulting in minimal revisions for the 25-26 Code of Conduct. We will discuss the Student Support and Positive School Culture Guide, and that is the document that has the proposed revisions. I have also submitted the 2024-25 K-5 Student Code of Conduct Infraction Level Guides and the 6 to 12 Student Code of Conduct and Infraction Level Guides. There was no feedback from any of the stakeholders on the infractions as it related to the infractions themselves. There was some feedback about the implementation of the infractions, but not the definitions of the or the coding of the actual infraction. So we will not have much to discuss as far as those go. So to jump in, the School Support and Positive School Culture Guide. The first change is under the non-discrimination notices on page 3. The Title IX officer title and contact information has been updated to include the correct title for Dr. Kimberly Cruz, Title IX compliance officer, and also to correct the email that is the Title IX compliance officer at pittsburghschools.org. Dr. Cruz also submitted additional recommendations which were accepted by the administration and committee to include language to strengthen the non-discrimination section as it relates to Title IX, to provide context for families or students' understanding of the law. Dr. Cruz provided some nice examples of what a Title IX violation may be for easy access, as well as this reporting chart that it's included directly in the text that shows what happens when you report a guide to Title IX, and it goes through the reporting process. Those changes can all be found on your policies for pages 3 to 5. Those are recommended to be adopted without editing as well. On page 6, this is a modern day update for the prohibition against bullying. It's simply updated the term Twitter to X and Musical.ly to TikTok. I apologize, the TikTok should not be crossed out on where it's going from Musical.ly to TikTok.
Right.
Under the investigation of bullying on page 7, we included, the administration, included the student services at pittsburghschools.org email address under the compliance office for student bullying and harassment. Okay, those are, now we're getting into some more substantive changes. On page 17, under the role of school security and safety staff, there was language that said that, excuse me, there is a moratorium on the issuance of summary citations for PPS students. The prior language said that that moratorium would be extended and remained in effect until no later than November of 2023 and maybe extended with authorization of the board. It was suggested by the ELC that we simply say the moratorium remains in effect, which the administration and committee agreed with. After the moratorium was issued, there was some discussion of the policy committee getting together with the safety committee to create a policy around issuance citations. That has not yet happened, and so we will leave it as is until a further date when that issue may or may not be raised by the policy committee and or the administration. So for now, the moratorium remains in effect and the policy reflects that. On page 18, with respect to attendance, there was a request to add a sentence at the end, which stated that a principal could excuse a student for a temporary period for urgent reasons. This was accepted, but also by including the phrase use their discretion. So we will now say that a principal may use their discretion to excuse a student for a temporary period of urgent reasons. Following on page 19 and still under the attendance category, the ELC and WBK recommended that the inclusion of a sentence that stated that when there is a referral to the Office of CYF for truancy, that we differentiate based on age. So for students 15 years of age or older, PPS may file a truancy citation against either the parent or the student, but not both. And then for students under the age of 15, PPS may only file against the parent. And that clarifies with whom PPS should look to file the truancy citation against based on the age of the student. I'll stop there, and if there are any questions or comments on any of those, the moratorium on citations and the attendance.
Okay, Gene Walker has a question.
So I have two. The first is on the moratorium. I mean, does it make sense to have that language say that the moratorium will stay in effect until the board takes action or different action? Or I mean, my guess is it's probably just never going to change, but I think there should be some language that says the board has the prerogative to act.
Yes, so you would like it to say something to the effect the moratorium remains in effect unless
until further board action is
until further board
exercised or
action,
something.
until or
Yeah.
unless further.
Yeah.
Okay.
I mean, I don't really expect it. It doesn't seem like this board is interested in changing that. And I don't know if there's a need to, but I think it should be an option for future boards. And then the other is on the truancy.
Yes.
What is the instance where we would file truancy charges against the student?
If they're 15 or older. So
Well, it says we can do either the parent or the student.
yes, and what was happening is that some schools were filing against both. And so it was causing a duplicative claim to be filed. So the ELC asked us to include this, and we agreed that it simplifies the process, and you're not, and I think it's case by case on whom they're filing it against.
Yeah, I was gonna say, who makes that decision if it's the parent or the student?
Well, it would be the person who's filing it based on the singular case of what's happening with the student. But we do not want to be filing against both the parent and the student because one would be kicked out either way.
Sure, no, I agree with that. My concern, I guess, is like, how do we to the best of our ability ensure, that it's not Black students that are getting charged, but white parents are charged more off, right? So that how do we protect our students the best? Because that's kind of what happened. That was the impetus around the moratorium, right? We shouldn't be criminalizing our students. So how do we ensure that kind of that racial or implicit bias doesn't impact Black students negatively, more negatively than it would any other? And you may not have the answer today because that's okay, but
I'm not sure that actually, I think that's more of an administrative side on how this is actually applied versus what's in the code. But I
okay.
don't know if anybody from the administration, but I would like to address that.
So we could, as an administration, just choose to say that the AR says that in all cases we will charge the parent, right?
I've known cases where parents actually brought, because their child was having truancy issues. I have known parents actually brought the kids to the school, and people
Okay.
saw the parent bring the kid to school. And the next thing you know, that kid disappeared out of a back door. And
Oh,
so in a
interesting.
case like that, that would be the student, not the parent.
Sure.
And
Yeah, I
that's
mean, I think
also, oh, go ahead.
I think I just want to make sure that however we write the policy, that it's not going to negatively impact Black students more than any others. Not that I want other students to be impacted negatively, but we know, whether it's suspensions or truancy or, citations, it tends to impact Black kids more. And so if we can, if we can write policy or regulations in a way that prevents that kind of bias from coming in, I think then we have a stronger policy.
Received. That would definitely be taken in consideration when we write the AR or amend it.
Thank you, sir. That was it for this part.
Okay. I don't see any further hands, any further questions, so you can continue.
Okay,
Statler.
all right, thank you. All right, next is the some updates to the dress code, which is found on page 21, or this particular section. Okay, so the first paragraph says it deals with the Pittsburgh and Allegheny County Crown Acts. And there has been a request for a few years from a few different organizations to include hair coverings and including other items such as headbands, head wraps, bonnets, barrettes, or beads. The administration approved this request, and so those are being added in so that they cannot be discriminated on the basis of those items if they are wearing them. And then the second paragraph, there was a request for a sentence to state that this is related to only students who attend schools with uniforms. That students who are experiencing homelessness under the McKinney-Vento Act will be provided with assistance obtaining a uniform. It's my understanding that the uniforms are plentiful in the district. There are many extras. And so the administration would be happy to help these students obtain a uniform if needed. And so this sentence was approved by the administration and the committee as well. And so this is the only section about dress code. So I'll just stop here for a second because then I'm going to move on to student conduct.
Seeing no hands raised, so I think you can go ahead.
All right, thank you, Director Wilson. Okay, so now we're moving on to the rules of student conduct, behavior, definition, and infraction levels. And this begins on page 22. On page 22, there is a list of nonviolent offenses. And as you can see, the nonviolent offenses are defined as an infraction or an offense that does not necessarily pose a threat to the health, safety, or property of others. Nonviolent offenses include all level 1 infractions and the following nonviolent level 2 infractions. And this is a list of nonviolent level 2 infractions. There has been a request to take out the undesirable group activity, which was agreed with because it is not defined anywhere within the code or within the infraction guidelines. And then on the next page, I'm going to move on to expulsion unless anybody has any questions on that. Yeah, okay. All right, expulsion. So we made a change on the page 26 for the exclusions from school. So this is when students are expelled from school, that they are still required to obtain an education. And they're still subject to the compulsory school attendance law. However, Ms. Golden asked that I remove the words that they're being educated at either the Student Achievement Center or Clayton Academy, because Student Achievement Center is not being used for students who are currently expelled from school. So that has been removed. And then on page 26 again, under the procedures, a student has a right to a formal hearing prior to an expulsion, and a copy of the expulsion policy and a notice that legal counsel may represent the student in the hearing must accompany the hearing notice. That the third point, it says a parent guardian has the option to waive their right to a formal hearing by accepting by accepting the discipline in lieu of proceeding to a formal hearing. It was recommended that we add the following clause, which has been accepted by the administration and committee, that says the parent must be presented with a waiver in writing prior to acceptance. And Ms. Golden can chime in if needed. It's my understanding that this is actually already happening, but so this is just sort of codifying that this is happening, but that the parents are presented, or at least should be presented, with their waiver in writing prior to accepting prior to accepting their waiver of the formal hearing.
Yes, I don't have anything to add. That's correct. We just want to make sure parents understand, and that information is in writing.
Okay, and so then, just to review, that was all of the changes that were recommended. Just to review the code of conduct timeline, again, this is an annual review. So last week, there was a pre-policy committee meeting where the committee and administration reviewed the proposed recommendations from the stakeholders. Today is the policy workshop, and this policy will then go onto the agenda review on June 18th, and then to the legislative meeting for a board vote on June 25th to ensure that it is approved prior to the beginning of the 25-26 school year. Getting ahead of myself. And that's all I have for that. So I don't answer any questions.
I didn't see any hands up. Oh, wait a minute. Now we have Gene Walker's up.
Yeah, I do have one more. And this is probably the same question that I've asked. Now this is my fourth time doing this. And this is my challenge with the code of conduct, is it focuses on the discipline of, this, or how we do discipline for the students who are being disruptive. But it doesn't, especially with the level 1 infractions, it does not account for how do we support the students who are losing education because these level 1 infractions don't actually have any bite to them. So it's like, we're working really hard, obviously, to keep our kids in school by not suspending them or doing these things, but we know that education time is being lost by lots of students because students understand that these level 1 infractions, and sometimes even the level 2 infractions, just have no bite to them, so they can just do whatever, and their fellow classmates are being harmed educationally. And I don't know what the solution is, but we've not, as of yet, addressed that through this policy, because at the end of the day, we should be trying to protect the education of all of our students. And even if they're in school, if they have 1 or 2 classmates that are taking up half of their period because they want to curse out the teacher and do whatever, I think we're missing something here, and I don't know what the solution is that doesn't then also, exclude more students from school. Does that make sense?
Yes, it does.
So I don't know if I necessarily a question, but just wanted to voice that I continue to have this concern. That, and we've talked to teachers, we've talked with administrators who are like, we don't have any recourse for ensuring that education continues for the majority of students because one or two kids want to act out and be disruptive. So maybe this is an administration question, not a legal question, but like, what do we do? How do we make sure that our kids can keep learning while also holding the kids who want to act out accountable for those actions? Like, what's the remedy?
So I could just say, Mr. Walker, from my perspective, is that, we have to, or we should be providing supports for those students. By way of referrals to our student assistance program, participation in perhaps different groups within our setting, referrals for school-based mental health services, but we also have Clayton Academy. And so that's for students with AEDY and, who meet the criteria, one or more of the 6 criteria for AEDY placement. And so one of those criteria is a persistent, violation of school rules. And so I would say that, when we have these circumstances, we first have to make sure that we're supporting the students. But to your point, if it's something where the school has exhausted all of the necessary resources, and then that's a placement that they should consider. And that's probably, some training that we have to do with our administrators, but that would be my input for that question.
And then have we defined what repeated, what is repeated? Like, is it 2 times? Is it 10 times? Is it 100 times?
So I don't think that it's ever been defined. But I can say that I think that, there are certain things that, again, from that classroom level to that administrator level, should happen. There should be that ongoing communication with parents. There should be, meetings and conferences and, again, referrals, for support services. So I think that, there has to be, while you can define it, it needs to be defined. I'm not certain that you put a specific number on, what does that, the number of incidents, what that is. Because I think people will hold to that more than, okay, how do we support this child and where are these behaviors coming from?
Sure. No, I get that. So then maybe the next step then is really kind of outlining what that process looks like. So we as a board can understand what the process is to when these next steps are triggered. Because, the last thing we want to do is continue to approve policy and then, have teachers and principals going, well, there they go, they're not listening to us again, right? We get that not just from the community when things don't go their way, but we also get that from our principals and teachers who are like, yeah, they say they support us, but here we go again. Like we're not addressing the root cause. And, we know who we primarily know who the young people are, who we need to support. But then we also know that the other 98% of kids who are losing out on educational opportunities because of this small number. So maybe that's the next step, is like, what is that, like defining when that first level of support happens, what happens if that first level of support isn't adequate? What is that next level of support? And I'm fine with a scenario where it's like, hey, we're going to try meeting with your counselor and your teacher, then we're going to call your parents in, and if they don't come, then we'll take step number 3, and then maybe step number 5 is Clayton Academy, or 6, I don't know.
Yeah.
But I think at some point,
yeah.
yeah, I think at
Go
some
ahead.
point, like, young people have to understand, like, they just can't keep doing the same thing over and over again, or doing multiple things once, right? Because, I think kids are smart if they figure out, hey, if I call my teacher, out of her name or his name 3 times, I'm going to get this. So I'm going to call my name, then I'm going to throw something at them, then I'm going to, turn my desk over, right? So there has to be, like, the infractions can't always be the same, but they just have to be an escalation or a continuation of a similar band of infraction. But I think ultimately, if they go, okay, geez, all right, now they're calling my mom. My mom doesn't really care, but now that I know that my mom's not going to come in, that moves me to the next step. Maybe I should stop doing that. I mean, as the consequences and accountability increases, I think that's what changes behavior. But ultimately, like we're trying to reaffirm, like we need you in the building, we need you in school because you can't learn if you're not in class. But we also can't let you take away from the learning of the other 20 students in the classroom. So thank you for that.
I was just going to say that's why Clayton was designed and developed because it was for those chronic disruptors that were constantly keeping the other kids from learning.
Mm.
It's just unfortunate that sometimes some of the principals, at least this is what I was told, they don't want to do the paperwork to send the kids there. But the intense supports are at Clayton to do just all the things that you just talked about. And I'm not talking about somebody who did something once or twice. We're talking about those that had a history of chronically disrupting the classroom and keeping the others from learning. But that is why it was developed. That's the purpose.
Well, no, that makes sense. And I think, I mean, my impression of Clayton, it was like, okay, someone did something illegal or got expelled, and now we're
Yeah,
sending them to Clayton, right? But I
yeah.
think that's the impression that folks have
Well,
if
that,
they know Clayton exists. Um,
yeah.
but no, I think that's helpful. And I mean, it's biblical, right? You take care of the 99, but you also have to take care of the one, but we can't sacrifice the 99 for the one. Um, when there are other remedies or solutions for the one that protect everyone. Sorry, I'm not supposed to bring the Bible into public schools, but here we are. And that was like Gene's interpretation of that.
Okay.
But that's it. I'll stop talking now. But thank you. I think this is helpful, but and that we're thinking about this. And thank you, Ms. Golden, for that clarification. Um, cool.
All right. Okay, Miss Sattler.
All right, thank you. One thing I would just note is that if you would prefer Director Walker, excuse me, we could look into this a little earlier next year if you wanted to sort of do more of a deep dive into that side of it. I could certainly talk to Ms. Golden about that. And trying to see if there are any other ways we could sort of tie up the policy to more address your goals that you were just speaking about.
I mean, yeah,
for the
I mean, I
next
think,
year, you know,
yeah,
to
I mean, I
kind of
think
like
that-
not just reinvent the wheel, but try to like actually expand on what you were saying. And I can talk to Ms. Golden about that maybe earlier in the year before we meet with the stakeholders. And then,
sure.
because they would
Well,
have good ideas. They had some good ideas, but they all require a lot of staff.
sure. Well, one, I appreciate your optimism that I'll still be here next year. And then two, I think it makes sense as we continue to work through, the new board governance policies, which would then, say that we need more than 30 days, to look at some of these major items. I think that makes a ton of sense.
Yeah.
But I know, right? These things that they pile on, we have a million major things we're trying to deal with, and they pile on each other, and it's hard to move that timeline. But I think, even another month would probably help as we kind of filter through some of this really important stuff. So thank you.
Okay, so as far as the infraction guidelines, typically how this process works is that we receive recommendations from the stakeholders, we bring them to the administration and then to the pre-policy committee and then to the board. We received no recommendations on either the K-5 or the 6 to 12 infractions. And it's, so I can go through those if you would like. I've sent those to you, or we can leave them as is. As is, okay. I think that they were heavily edited a few years ago. That's my understanding. Director Wilson is nodding, so I think I'm correct. That was before my time here at WBK, but so those probably, and like I said, we did not receive any information or any requests for changes from any of the stakeholders. In fact, certain stakeholders said they had no requests at all, so I thought that was a good sign for what a good job everybody did last year. So if that is it, then that is all I have on this.
Okay. All right, we've gone through 3.
I'm sorry?
We've gone through all 3.
Well, I
Well,
didn't know,
she just asked if we wanted to do
Because,
the,
because there's no changes, so that's it? Okay,
correct, yes.
all right. Then do we have any final questions? From any of the board members that are still on?
If I could just note, the infractions were submitted and I will ask that they be submitted on the website as well for community review for the next 30 days, but again, there were no recommendations for changes to those.
Okay, thanks. It just seemed like, gee, this can't be possible that we would get through this as quickly. Mr. Walker, there are a lot of steps before anybody would be recommended to go to Clayton. I'm sitting here thinking about that, conferences, modifications, all kinds of things, you have to note, and all the things that you do to try to work with that student.
sure.
And if that student continues to be so much chronic, so disruptive, then that finally you say, okay, we've done this, this, and this, worked with the parents. All of these interactions have not worked, and then that's why they're recommended there. And like I said, at that school, there are all kinds of interventions and heavy support that are trying to get that behavior turned around.
Understood.
I didn't know if I was clear enough. I just, that was something that we worked on very hard to get that in place years ago. All right, then, seeing no more other questions, I'm so surprised. We are obviously done with our meeting this evening. And I thank everyone for all the hard work that goes into this year, but every year. And I wish you all a good evening. Good night.